May it please your lordship, my lord.
Yes.
Well,
Yes.
may it please your lordship, my lord.
Yes.
My lord,
please.
item 27, my lord, of today's list, my lord. My learned friend from the petitioner side is also present, Mr. Das. My lord, there is a possibility of some reconciliation between the parties. So may we jointly pray, my lord, that let the matter be placed before the mediation so that we can arrive at a logical conclusion of the entire issues.
Matrimonial dispute, madam.
Okay.
Well,
27, item 27.
27, item number.
Okay. Item 27. Mr. M.K. Das, then counsel for the petitioner, and Dr. A. Samuel, and counsel for the respondent, submits that this is a matrimonial dispute and therefore the court deems it appropriate that the matter be listed before the be sent for mediation. At the this is parties are from which place?
Gauhati, madam.
From Gauhati.
Guwahati, my lord, Guwahati.
The
All are from Guwahati.
Gauhati High Court Mediation Center. As per the charge of the Gauhati High Court Mediation Center shall appoint a trained mediator to make an attempt to settle all the dispute between the parties through mediation. Full stop. Both the parties are directed to appear before the Gauhati High Court Mediation Center on, give us a date when you want to appear.
My lord,
When you want to appear.
my lord, from 5th to 12th, I will be out of station. After that, my lord, any date.
June. June.
Okay, on 15/6/2026.
15 June, my lord.
List on 17/7/2026, awaiting report from the mediator. Okay.
Deeply obliged. May I please, your lordship, with the consent of the other side, I beg to mention item number 14, lordship.
14.
Yes, lordship. I am for the respondent in this matter, lordship.
Okay, with consent of the other side, Mr. K. Jain,
Lordship.
then counsel for the respondent, prays for adjournment. There is a lot matters since adjourned today. List, give a date after 2 weeks.
Lordship, can it be taken on 12th? 12th of June, Friday.
We'll just examine and then
Lordship.
give a date.
Much obliged.
Lordship, I wish to mention a CRP for orders. Any detail?
This thing, please give it to the court counsel. We'll have to make some adjustments.
Deeply obliged.
May it please, Your Lordship. Lordship, I beg to mention item number 3. Lordship, in this matter, we have filed our additional affidavit. Lordship, however, it came to our knowledge that there are some defects in the additional affidavit, Lordship, which need to be rectified.
You're for the petitioner.
Yes, Lordship. Lordship, I pray if this matter may be listed next week.
Okay, list after a week as prayed for by learned counsel for the petitioner.
I beg to mention item number 10, Your Lordship. The senior advocate is out of station. We already take the concern of the other side.
10 is 2017 matter, sorry. We'll look into file then consider. Please renew the prayer when the matter is called. No, Mr. Kalita, this is 2017 matter. We are unable to adjourn it on the prayer without looking at the records.
May I please, Lordship? I beg to mention item number 20. I am for the respondent in this case, Lordship. Yesterday we have got the news about he was expired in the year 2020. Sole respondent, Lordship. His legal year may be substituted in this case.
You have filed the death certificate? No.
Lordship, I have to.
Just give the records. Just wait for some time. Yes,
I'm for the appealant.
just wait for some time.
May I please, your lordship? I beg to mention item number 17, lordship.
7.
17.
17.
Pacemaker, Lordship, I pray for 2 weeks time there. I have to take some instruction, Lordship.
Just after 2 weeks, I prayed for one and counsel for the appellant.
May I please, Your Lordship? Your Lordship, I beg to mention item number 9 and 22, Lordship. Finally, the matter may be passed over for the day, Lordship.
9 and
9 and 22, Lordship.
9. Just after a week, I prayed for one and counsel for the
Appellant, Lordship.
petitioner. The government advocate is present. And item number
Item number 22, Lordship.
22. You have taken consent of the other side?
My senior has taken, Lordship.
Okay. Consent of the other side.
My
The
lord.
counsel for the petitioner prays, appellant prays for adjournment. There is a note. Just after 2 weeks.
Oh, it took 2 weeks, sorry.
Yes.
May it please your Lordship. Lordship, I beg to mention item number 1, Lordship. Lordship, in item number 1, on last day, the Honorable Court had given us liberty to produce the cross-examination of the PW, Lordship. But that document could not be traced out, Lordship. So some time may be given, Lordship.
How much time?
2 weeks time may be given, Lordship.
Okay. Just after 2 weeks, I prayed for well and counsel for the petitioner. Okay.
Obliged, Lordship.
May I please, Lordship, I beg to mention item number 19, Lordship, kindly adjourn the matter for a day, Lordship.
Okay. Just after a week, I prayed for well and counsel for the appellant. Yes.
Item 20.
You are appealing for the respondent.
I'm for a respondent.
Your name?
N. Thakuria for S. Salman. Satyajit.
Mr. N. Sharma.
N. Thakuria.
Aguria, another counsel. You are for the appellant.
I'm for the
Okay, both sides are represented. Mr. N. Thakuria, another counsel, appearing on behalf of Mr. S. J. Sharma and the counsel for the appellant, has produced a copy of the, photocopy of the death certificate of the correspondent who has expired on
C820.
3/8/2020.
Fine.
This 2020.
Yes, it's C820.
3/2020. Full stop. Accordingly, first of all, said this copy of the said death certificate is retained on record. Accordingly, the then counsel for the petitioner has discharged his obligation under order 22 rule 10A of the CPC. And counsel for the your name?
M. Das.
Mr. M. Das, and counsel for the applicant shall take note of the said submission and do the needful. Next para list after. How much time?
I have a small prayer, Lordship. Because there will be asked to produce the details of the legal aids, something. Details of the legal aids, Lordship. The sole respondent, Lordship.
And then, however, the learned counsel for the respondent on the next set of listings shall inform the names of legal representatives of the deceased respondent. Next one, list after 2 weeks. Due date after 2 weeks, this is 2014 matter.
Obliged.
Item 2 for motion.
Make with your lordship. So let your lordship will find the Indian order at page 51. The lordship kindly takes up from page 53, my lord. May I read the relevant portion from page 53?
Order 9/13 was allowed.
Yes, ma'am. And it was allowed after 4 years of passing of the decree and after 2 years of filing of the execution case, at a stage when the sale deed in connection with the contract which was for which specific performance was sought for was at the stage of being finally drafted under Order 21 Rule 34. Now, the petition has been filed by one out of the two sisters of the party to the contract who died, and the suit was filed against the legal heirs of the deceased party to the contract. Out of two, one never contested. In fact, upon both the defendants, the service was held to be complete by an order. Now, thereafter, the suit proceeded ex parte and there was an ex parte decree. Now, when the decree was put for execution, one of the sisters, who is the defendant number 2, she came forward. The defendant number 1 did not come forward. Only defendant number 2 came forward with a plea that the summons were not properly served upon her. And she also cited the discrepancy of the name and also the fact that she does not reside in the address on which the summons was set
She
to
says that some impostor appeared.
That is her contention that she made. No, nobody appeared in the suit. The suit proceeded ex parte. Now, according to her, the summons that was said to have been served on her in the suit proceeding, that was not correct. But here, my lord, the order by which the report of the process server was accepted, that order was never challenged. That order remained as it is. The learned court below wide order dated 30/10/2018 had come to the finding that on defendant number 2, the summons were duly served, and since she failed to appear and contest the case, therefore the suit was ordered to proceed ex parte against her.
There is the statement here in your application
Yes.
that the address given in the plate for us, the defendant number 2 was the
Yes.
correct address.
Yes. we filed objection against the petition under Order 9, Rule 13. That we have annexed in as Annexure 5, and our statement in our this instant revision petition, your lordship kindly takes up paragraph 5 at page 7.
You see, apparently, we find the orders, that order has to be upheld. The reason is,
My lord.
come to page 22, that is your plaint.
Yes, ma'am.
You give the address at Daughters of Karunamay Sheel, care of Babul Sarkar.
Yes, ma'am.
Now, who is this Babul Sarkar? And why will a married lady live with at the care of someone? In her application, she says she is the wife of Bimal Kumar Chanda.
Yes.
Now, if she's a married woman aged 59,
Well,
definitely in 2018 also she was a married woman.
my lord, so far,
She is now 59. We don't expect her to be married after 2018.
my lord, so far this address is concerned, my lord. On this address, on the same address, there is another suit at page 10, if your lordship kindly sees. She had filed one title suit number 62 of 2017, which was subsequently renumbered as title suit number 79 of
Page number?
page number 10 of my revision petition. It is a continuation of the paragraph of the paragraph number 6, starting from page 8. I am troubling your lordship with page number 10. This is the evidence that she adduced during the proceeding of Order 9 Rule 13 application. Now, if your lordship kindly sees that some 1, 2, 3, 4, 5, 6, 7, 8, 9, 10th line from below, your lordship will see there's a line, she further admitted that she had filed title suit number 62 of 2017, which was later renumbered as title suit number 79 of 2021 in respect of 1 khatha, 8 jathas of land on the eastern and western side, which the land of Pradeep Sheel is situated. She further admitted that she neither arrayed the petitioners and parties in her suit, nor anyway challenged the decree passed in title suit number 98 of 2018 in her suit, except the evidence of respondent herein. No further evidence was adduced. Now, this was one suit that she had filed, and in our evidence, your lordship will kindly takes up paragraph 7.
This is a part of your revision petition.
Yes,
Where is the document?
that document is not with us, my lord. That
Come to
it is
page 21.
page 21. My lord,
1 to 11 are matters of record.
my lord, this is regarding this filing of title suit number 62
That
of
we don't know. Page 21, your affidavit says these
my
are
lord,
matter of record.
It's a matter of record.
You don't show us anything.
My lord, this of course we could not because in this, as we have made a statement that we were not made parties in this case.
It's
We-
okay, but you'll have to, you see, we are now concerned with this suit.
My lord, my lord. Here, my
We,
lord,
we don't know whether that piece of evidence was tendered in
I
the
understand.
proceedings of this
I
order
understand.
9/13.
I understand. But one thing, my lord, if your lordship kindly takes up one more document, which we filed on the direction of this honorable court, that is an affidavit and
No, no, you see, these are all statements which are all permutations and combinations. Something can be right, something can be wrong.
my lord. But my lord, we annexed the order.
No, not that. You see, I am sitting here right now. Somebody goes to my residence and serves the notice there.
My lord.
They will not find me there.
But my lord,
So
here,
therefore, if I take a plea that I was on that day in the court, presiding the court and therefore was not there,
Well,
could be also a good defense.
now, my lord, so far this aspect is concerned, that could have been best established or ascertained by examining the process server who says to have served it, and the court had accepted by the order dated 30/10/2018, which we have brought on
No,
record.
but you, if you say something, which is a matter of record, you show us the record.
My lord, this is on record. This is by way of an additional affidavit that we have filed.
Which one?
This order dated 30/10/2018. This is the order during the suit proceeding, wherein the report of the process server was accepted by the learned court below, and wherein it was held that summons issued to the defendant number 2 is duly received as per the report of the process server. The defendant number 2 has failed to appear and contest the case. Accordingly, the suit will proceed ex parte.
But here they say that that was a fictitious address.
Now, that is where, my lord, once in this report as well as pursuant to the report in the order, it has
No,
been.
no, you show us document. These things don't.
Sir,
doesn't
that is where, my lord, when the proceeding under Order 9, Rule 13 was initiated, she adduced her evidence.
But where is the document? You are asking us the document. You don't show that.
My
You're
lord,
making a
this is by
statement.
way of an additional affidavit, my lord. At
That
page
is
50
only the process server's report.
no, this is the order of the court.
Correct.
Yes.
Accepting it.
Yes, yes.
But where is the process server's report
That,
that it has been served?
that is by way of,
Then-
that is also,
Once somebody is being proceeded ex parte and she comes and says that it's a fictitious address,
my lord.
you have to.
And when, my lord, one humble submission here, she filed a petition under Order 9, Rule 30. But she did not make any endeavor to get the process server examined during the proceeding at any point of time. My lord, what I am on is that during the proceeding under Order 9, Rule 13, she did not make any endeavor to bring the process server before the court,
This statement court feels that it is good.
my lord.
It's not required to be proved,
Well,
not required to be proved.
My lord, that aspect is what we are agreed with, that the learned court
No,
below.
no, we
without-
approve that. Otherwise, this suits will never end. For everything, the court will not take evidence.
My lord, so far,
If the court records the satisfaction that the address was fictitious,
my lord,
what is wrong in that?
well, that is, the court has arrived at the satisfaction only on the basis of the fact that the address are different and the name
No,
doesn't
even you
tell.
see, you are saying that in earlier suit that was the same address. Even you don't prove that.
My lord,
Then,
but so far other aspects are concerned, we led
no, you are
evidence
not
that was
interfering.
not,
It's an ex parte order. She says it's a fictitious address.
my
Now
lord.
you are trying to show it's the same address. And you don't lead the evidence.
My lord, my humble contention, since it was her petition, she failed to establish that she.
No, many a times we accept the
My-
statements of the lawyers.
My lord,
You give us a statement, the lawyer in the earlier case showed me a death certificate. We
My-
accepted it,
my lord,
recorded the question of death.
My-
It leads to abatement of a appeal.
my lord,
Still we accept it.
My-
It's a counsel making a statement.
my lord.
And if the man comes and says that I am a married lady
My lord,
and I'm not staying there, then
and my
now
lord,
please give me, please answer a query.
my lord.
Today, you go to the place of B. In B, some incident happens and you have to require for the location which is A. You are at B. Can't you give an address of B and lodge an FIR that I am now residing temporarily here? This has happened and therefore I give my address as B.
My lord.
Now,
I understand.
now can somebody file a suit? Z will file a suit against you saying that in that FIR you gave a statement that you are a resident of B. And therefore this is his correct address?
My lord, I understand
No,
what
no,
is
no,
calling
these
from
things
you.
are subjective satisfaction.
My lord, one more aspect, my lord, may I submit, if your lordship allows. Regarding her contention in the Order 9, Rule 13 petition about the date of knowledge of the decree, after which she came before the court below in filing the Order 9, Rule 13. That is also something that my lord, in my humble contention, it is her bounden duty to prove before the learned court below. But she simply mentioned the date, that from that date, she came to know about the decree, and that is
Possible.
Well-
Please tell us why it is wrong. Why it is so false that we will not believe it.
because, my lord, my understanding is the decree was of 2018. We filed an execution case in the year 2020. She comes up in 2022, and only she comes. There was another defendant who never came. She comes and says that the decree is, and she also alleges that the decree is obtained by fraud. But whereas in the proceeding under Order 9, Rule 30, she has not made any whisper as regards the valid contract that was entered between me and her deceased brother.
Is this a mini trial for the suit?
No, that is of course something that
No, Mr. Chakravarti, this thing
I
doesn't matter
understand.
to us.
Anyways, my lord, the direction by the learned court below is now that the suit should be restored to the earlier position, and now I think the next date has been given for filing of written statement by defendant number 2.
Well,
That is on 3/6.
why can't somebody have a knowledge of this thing happened on that day?
I understand, my lord, because the surname, there is a discrepancy that I see. So, in that view of the matter, the learned court below,
You see, answers are very simple. I'll just dramatize it for you. You see, you go to a soothsayer, a person who reads the palm. He reads the palm and tells you your future. So how can you say that it's not a science at all? He looks at your palm and then tells your future. Why this person will not know there is an execution case pending against her? People in the neighborhood will tell the process server will go there and they will announce. Why somebody will not know? Please tell us one reason, good reason. Why an alert person would not know?
that is my contention, my lord, that she is not expected not to know. In 4 years, her own sister knows that the decree was passed, but she comes after 4 years contending that she never knew about
I have a brother which I am not in talking terms.
that, of course.
Then,
Is-
so you see, every statement made like that will encounter hundreds of permutations and combinations.
my lord.
Is it required that you see, you have seen you are a seasoned lawyer, you have seen many litigations. Have you not seen any litigation where a person files a probate for a will and the other brother comes and says, I never knew, my father lives with me, I don't even know how the will was made in name of B, who resides elsewhere he resides in London, and then will is on his name. He doesn't take care of my father. I am residing in Thekesville, I am taking care of my father.
That's the
Then-
common plea, my lord. That is what
then-
I say.
All these have many permutations. We can endlessly go on.
My lord, I leave it up to your
No,
lordship.
no. Once you show something substantive, then it's separate.
Understood.
Mr. D. Chakravarti, learned counsel for the petitioners. That by filing this application under Article 226 of the Constitution of India, the petitioner has said the order dated 31/3/2026, passed by the learned civil judge, bracket senior division, bracket was number 2, Kachar Silchar, thereby allowing NISJ case number 50 of 2022 in TS 98 of 2018, thereby allowing the application under Order 9, Rule 13 CPC, resulting in setting aside of the ex parte decree dated 2012-2018, passed in TS number 98 of 2018. Next para. The learned counsel for the petitioner has submitted that by way of an additional affidavit filed on 12/5/2026, the petitioner has brought on record a copy of order dated 30/10/2018, passed in TS 98 of 2018, by which the process server's report of due service of summons on defendant number on the
Defendant number 2, my lord.
no, here she is
Here she is the sole respondent.
on the respondent within bracket defendant number 2. And as she did not appear and contest the proceedings, by order dated 30/10/2018, the learned trial court ordered the suit to proceed ex parte against the petitioner within, respondent within bracket defendant number 2. Full stop. By referring to the statement made in paragraph 6 of this application, it is submitted that the address in which the summons was served in TS 98 of 2018 is the same address referred by the respondent in title suit number, which case?
Title suit 62 of 17, renumbered as 79 of 21.
Okay. Where is the number?
Page number 10. 10 lines from
TS 79 of, TS number 62 of 2017, later renumbered as TS 79 of 2021. So accordingly, it is submitted that the plea of the respondent that the summons was fraudulently served does not carry any weight. So it is submitted that no fraud was committed by the petitioner's plaintiffs in serving notice at the same address which is disclosed in TS number 62 of 2017. Next, the learned counsel for the petitioners has further submitted that the defendant number 1 in the suit also did not contest the proceedings despite service of notice, and it is surprising that though the respondent claims to have no knowledge of the ex parte decree, but she suddenly files the application for Order 9 Rule 13 CPC and discloses a fictitious date of (33) 2022, on which she allegedly got knowledge of the said ex parte decree. Dated 20/12/2018. It is also submitted that the respondent has not adduced any evidence, and therefore the learned civil judge within bracket senior division bracket close number 2, ought not to have allowed the application. Next paragraph. On a perusal of the documents annexed to this application, committee has noticed that the respondent has taken a plea that the summons of the suit was served on a fictitious person named Pushpanjali Sarkar, and thus ex parte decree was obtained. And she had denied putting her signature in the summons. So it appears from the contents of the order dated 31/3/2026, wherein the learned trial court had referred to certain documentary exhibits. Thus, it appears that some evidence was recorded in connection with Niche case number 50 of 2022. The learned trial court had referred to exhibit 8, which was issued by the secretary, Meherpur Gaon Panchayat, stating that the respondent, daughter of late Karunamoy, Karunamoy, Shil, Shill, of Kuwarpur, Kuwarpar, Meherpur, Meherpur, is married to Bimal Kumar Chanda, resident of Durganagar, Tarapur, was married on 1/3/1991 to Tarapur. The said learned court had also referred to Exhibit 9, which is a copy of the pension payment order, Exhibit 13, copy of the passport, Exhibit 14, copy of Aadhaar card, Exhibit 15, copy of electoral voter identity card. And he thereby denied the address given in the process service report within bracket Exhibit 17. And arrived at a conclusion that the signature in the process service report within bracket Exhibit 17 within bracket 1 does not tally with the signature of the petitioner. Accordingly, the ex parte judgment and decree dated 20/12/2018, where the decree was drawn up on 4/1/2019, were set aside, and the proceedings of TS 98 of 2018 was restored to file. Full stop. There is no material in this application to show that any effective evidence was tendered by the petitioners to deny the deny the projection of the respondent that she was not a resident of the place where the summons was served. Stop. Next paragraph. The petitioners had an opportunity to counter the stand of the respondent by producing the records of TS 62 of 2017, but the impugn order does not show that the same was done. So accordingly, this court, in exercising jurisdiction under Article 227 of the Constitution of India, would not take note of any additional fact which is hitherto not pressed into service before the learned trial court. Next paragraph. Accordingly, the order dated 31/3/2026, passed by so and so and so and so, page 51. Would not be shown to be perverse or contrary to the established principles of law. Accordingly, the court is disinclined to entertain this application, and accordingly, this application is dismissed. Next, the registry should transmit a copy of this order to the learned civil judge within bracket senior division, bracket close number 2, research feature, to make it a part of record.
But one thing I beg to point out, this petition I have not filed under Article 227. I filed it under Section 115.
Okay. Yes, 115. Okay, thank you.
Obliged.
This is I closed. No, closed and dismissed. Yes.
May I please, Madam? Madam, this is against injunction order, Madam. Petitioner before the lordship of the defendants in the suit, Madam. Madam, the suit is filed under section 134, 135 of the Trademark Act, Madam, for passing of action, Madam. Trial court granted injunction against that the petitioner has preferred appeal. Appeal also dismissed, Madam, then the CIP, Madam. Madam, the order passed by the trial court.
This would have been a commercial suit.
Yes, commercial suit, Madam.
Is second appeal maintainable? No, by revision, second appeal would be maintainable, no?
Madam, against the injunction order.
If I may, but principle would be same.
Yes, Madam. So appeal already filed before the honorable district judge, Madam, under order 43(1)R, Madam. That's why dismissed, Madam.
Okay.
Your Lordship, if I may be allowed to submit something before the lunch. Lordship, there is a issue with regard to the maintainability of this revision case, both under the Commercial Courts Act as well as under the very section under which they have filed, under 115 of CPC as well. So Lordship, I request that before the court can hear the merits of the case, if the issue of maintainability is decided first.
Make your submissions.
Yes, Lord. May I start, Lord?
Yes.
Lordship, the original suit is a commercial suit, Your Lordship, where an interim order has been granted. Against that interim order, Your Lordship, an appeal has already been preferred and it has been dismissed. So, Your Lordship, if the Lordship may kindly take up the Commercial Courts Act of 2015, Your Lordship. There is a bar against revisional petition against an interlocutory order.
This will not be interlocutory order, it will be a final order of adjudication.
No, Your Lordship, they have challenged the appellate order, and the appellate order was, the appeal was filed against the interim order, Your Lordship. The case is still pending, Your Lordship. Your Lordship has a Commercial Courts Act. Lordship may kindly come to section 8 of the Commercial Courts Act.
Yes.
Lordship, Section 8, bar against revision application or petition against an interlocutory order. Notwithstanding anything contained in any other law for time being in force, no civil revision application or petition shall be entertained against any interlocutory order of a commercial court, including an order on the issue of jurisdiction, and any such challenge, subject to the provisions of Section 13, shall be raised only in an appeal against the decree of the commercial court. Now, Your Lordship, by this revision petition, they have challenged an appellate order, Your Lordship, but the appellate order,
Continue, please
Your
continue.
Lordship, the appeal was preferred against an interlocutory order. It is a well-settled principle, Your Lordship, which has been reiterated by the Supreme Court in a number of cases, that what cannot be done directly cannot be done indirectly as well. So, Your Lordship, what they have done is, under the disguise of a civil revision petition, they are trying to file a second appeal against the very interlocutory order, Your Lordship, which is expressly barred by the Commercial Courts Act. The Commercial Courts Act, Your Lordship, it's a special act, Your Lordship, which has been enacted for speedy disposal of commercial disputes. In order to do that, Your Lordship, the legislature at the time of enactment had laid down certain restrictions with regard to appeals and revision under the Act, Your Lordship. The restrictions with regard to appeal has been laid down in Section 13 of the Act. With regard to revision, it has been laid down in Section 8, Your Lordship. So, Lordship, under the Commercial Courts Act, this is not maintainable. Moreover, if Your Lordship looks at your petition, the cause title, it has been filed under Section 115 of CPC, Your Lordship. Now, this petition is not maintainable under that very section also, Your Lordship. If Your Lordship may kindly take up the CPC, Your Lordship, and come to Section 115.
Yes.
May I read slowly? The High Court may call for the record of any case which has been decided by any court subordinate to such court, and in which no appeal lies thereto. And if such a subordinate court appears to have exercised the jurisdiction not vested in it by law, or to have failed to exercise the jurisdiction so vested, or to have acted in the exercise of his jurisdiction illegally or with material irregularity, the High Court may make such order in the case as it thinks fit. Now, Your Lordship, the next part is important, the first proviso. Provided that the High Court shall, under this section, vary or reverse, Your Lordship, provided that the High Court shall not, under this section, vary or reverse any order made or any order deciding an issue in the course of a suit or other proceeding, except where the orders, if it had been made in favor of the party applying for revision, would have finally disposed of the suit or other proceeding. Your Lordship, the first proviso lays down a precondition, Your Lordship. Lordship, if in a hypothetical situation, if for argument's sake we assume that the revision petitioner succeeds in this petition, this will reverse the appellate order, which in turn will put a stay on the interim order only. But it will not dispose of the suit, Your Lordship. That suit will still remain pending. The revisional jurisdiction under Section 115 of a High Court has always been narrower, Your Lordship. But by an amendment in the year 1999, by which this proviso has been enacted, they made it more narrower, Your Lordship. Under both the Commercial Courts Act as well as CPC, Your Lordship, this is not maintainable. The provisions are crystal clear, Your Lordship, but if Your Lordship permits me, I would also like to rely on a few judgments.
Yes. Yes.
Lordship, paragraph 32, page 674. May I read, your Lordship?
Yes.
Paragraph 32. A plain reading of section 115 as it stands makes it clear that the stress is on the question whether the order in favor of the party applying for revision would have given finality to the suit or other proceedings. If the answer is yes, then the revision is maintainable. But on the contrary, if the answer is no, then the revision is not maintainable. Therefore, if the impugned order is interim in nature or does not finally decide the list, the revision will not be maintainable. The legislative intent is crystal clear. Those orders which are interim in nature cannot be the subject matter of revision under section 115. So, Lordship, what they have challenged is indirectly the interim order. This is strictly barred by section 115 itself, your Lordship.
Yes.
Your Lordship, recently also the Delhi High Court in a very similar case, your Lordship, was dealing in a similar issue, your Lordship, where a revision petition was filed against an appellate order. The appeal was against an order of the commercial court, your Lordship, similar to this matter, your Lordship. In that case, your Lordship, revision was preferred under Article 227. However, your Lordship, reference has been made to Section 115 also, your Lordship. Paragraph 29.
Twenty-nine.
29 and 31 are the paragraphs, your Lordship. 29 and paragraph 31.
The Delhi case.
Yes, your Lordship.
Delhi case only has 14 paragraphs, 16 paragraphs.
Your Lordship, I think I've provided with his all. Sorry, your Lordship, this name of the cases are similar, your Lordship. Itu ani dibo. Itu Lordship. Paragraph 29 and 31.
Yes.
Paragraph 29. A petition under 227 of the Constitution of India is a discretionary remedy and which discretion is ordinarily not exercised when an alternative remedy is available under CPC. In Suryadev, Rai Supra, as well as in Punjab, your Lordship may skip it, it has been held that Article 227 cannot be invoked where the remedy of appeal or revisions are available. Thus, the whole Section 8 of the Commercial Courts Act, a petition under Article 227 would not have been entertained against an order of dismissal of an application under Order 7, Rule 10 of CPC for the reason of the statutory remedy of revision petition being available to the petitioner's defendants. The exercise by the High Court of powers jurisdiction under 227 is subject to well-known, well-settled rules of self-discipline and practice. Such jurisdictional power is not to be exercised in derogation of statutory provisions. In Koyalerian Janaki versus Grand Controller, it was held that it was not appropriate for the High Court to have interfered with the order in exercise of powers under Article 227 when proceedings arose under a special act which did not provide for second appeal or revision to the High Court. That the purpose behind not providing such a remedy was given finality to the order passed under the Act. Similarly, in Niaz Ahmed Khan versus Mahmoud Rahman Ullah Khan, it was held that the powers of superintendents under Article 227 cannot be exercised in a manner ignoring or violating the specific provisions of the statute, and that the High Court, while purporting to exercise powers under Article 227 to keep inferior courts and tribunals within the limits of their authority, should not cross the limits of its authority. To the same effect is Sunita Rai versus Sri Shalapan. It was held that though no hurdle could be put against the exercise of constitutional powers of the High Court, it was a well-recognized principle which gained judicial recognition that the High Court should direct the party to avail of statutory remedies before resorts to constitutional remedy. The petitioner under Article 227 was held to be not maintainable owing to the availability of remedy of an appeal under CPC. In Suryadev Rai Supra also it was held that to safeguard against a mere appellate or revisional jurisdiction being exercised in the garb of exercise of supervisory jurisdiction under Article 227, the courts have devised self-imposed rules of discipline on their power. Supervisory jurisdiction may be refused to be exercised when an alternate efficacious remedy by way of an appeal or revision is available to the person aggrieved. It was held that the High Court should have regard to the legislative policy formulated on experience and expressed by enactments, where legislature in exercise of its wisdom has deliberately chosen certain orders and proceedings to be kept away from exercise of appellate and revisional jurisdiction in the hope of accelerating the conclusion of proceedings and avoiding delay and procrastination, which is occasioned by subjecting every order at every stage of proceeding to judicial review by way of appeal or revision. Lordship, paragraph 31, Your Lordship. We are of the view that once the Commercial Courts Act has expressly barred the remedy of a revision application under Section 115 of the CPC with respect to suits within its ambit, the purpose therefore cannot be permitted to be defeated by opening up the gates of Article 227 of the Constitution of India. The scope and ambit of a petition under 227 is much wider than the scope and ambit of a revision application under 115. Whatever can be done in exercise of powers under Section 115 can also be done in exercise of powers under Article 227 of the Constitution. Allowing petitions under 227 to be preferred against orders against which a revision application under Section 115 would have been maintainable, but for bar of Section 8 of Commercial Acts would nullify the legislative mandate of the Commercial Courts Act. It has clearly held this, Your Lordship. There is a bar against revision petition against interlocutory orders, Your Lordship.
Okay. Yes,
My lord, the application for injunction. Or may I pray that Lordship may take up on Monday, my lord? This aspect,
no, having spent some time, there is no adjournment. This is question the maintainability.
yes, my lord. I have not looked into this
If you
aspect,
wanted
but
to raise that, you could have objected to earlier to take an adjournment, but having heard it, having read two judgments in the meanwhile, you can't adjourn it.
my lord, my submission is that, my lord, the application for injunction was filed under Order 39, 1 and 2, my lord. And my lord, the state proceeding by the.
That's why you see, when you started, the first question was, it was a commercial suit.
No,
Once it's a commercial suit, then the regular CPC takes over,
no, lord.
and the precedents should come to the, CPC will go to a backdrop, and the Commercial Courts Act will prevail. And only those paragraphs which find amendment in the CPC relating to Commercial Courts Act will prevail. If there is a statutory bar, then we have to show us why should we interfere.
That's why I said Lordship may take up on Monday, my lord. I will-
No. You can at best adjourn it till 2 o'clock. Till 2 o'clock.
Okay.
Yes, item 5. May I please, my lord?
In this matter, my lord, your lordship has given us liberty to bring into record two more documents, my lord, by filing additional affidavit, my lord. So we have filed additional affidavit, my lord. What is the impugn order? Impugn order is at page number 69, my lord, annexure 7. Order dated 30th of August 2025, my lord. Page number 69, my lord. Yes. My lord, now by this order dated 30th of August, my lord, the cross-examination of the plaintiff witnesses has already been closed, my lord. And on all the occasions, the Angus counsel, this government pleader, my lord, he has taken time for personal reasons, my lord. And those are reflected from the orders, my lord. The order starts from page number 54, my lord. And regarding the closure of evidence, cross-examination, my lord, that was informed to us only after 30th of August, when the order was passed. After that only, we were informed, my lord.
What is the date of your information? My lord. After 30th of August, my lord, there was the last order that the order of closure was passed, my lord. 30 August. 30 August, my lord. Page number 69, my lord. Okay, after the order was passed on 30 August. Okay, yes, my lord. Then what happened? Thereafter, my lord, the petitioners had filed a petition before the learned court below. They have prayed for allowing them to cross-examine the plaintiff witnesses, my lord, and as well as to engage the legal aid counsel, but the prayer was rejected, my lord. The petition is at page number 60, my lord, annexure 70, my lord, annexure 8. Okay. Heard. Your name? A. Basumatari, my lord. Mr. A. Basumatari, I am counsel for the petitioner. Petitioners. By filing this application under Article 227 of the Constitution of India, the petitioner has said the order dated 30/8/2025 and 30/3/2026 passed by the learned civil judge, bracket junior division, bracket close number 1, Gauhati. Thereby closing the cross-examination of the EWs and reject the prayer to engage legal aid counsel. Next, it is projected that the petitioners are the defendant numbers 1 and 2 in the TS number 41 of 2022, which has been contested through the government advocate. This alleged that the government advocate had taken several adjournments without informing their petitioners and without their consent, which resulted in closure of the cross-examination. By it is projected in annexure 8 of the application that the petitioners have come to know from reliable source that the counsel for the plaintiffs and the government advocate representing the respondents were relatives. Next, issue notice returnable on so and so. Petitioners shall take steps for service of notice on the respondents. As well as the proper respondents by speed post with AD. Issue notice returnable on censor. They give the date after 4 weeks. Extension for service. In addition to steps to be taken on respondent numbers 8 to 13, requisite extra copies of the revision application be also served on the office of the senior government advocate. For respondent number 11 and 12, for the standing counsel for the Revenue and Disaster Management Department, for respondent number 8, and to the learned standing counsel for the School Education Department, representing respondent numbers for respondent numbers 9, 10, and 12. The copy of acknowledgement shall be produced on the next date of listing. Next paragraph, till the next returnable date. The further proceedings of title suit number 41 of 2022, pending for disposal before the court of Learned Civil Judge, Junior Division, post number 1, Golaghat shall remain state. However, the petitioner shall produce a copy of the certified copy of the order before the said land court. It will be ordered to the notes of the said land court. This transfer.
Item 6 for motion.
Lordship, when this matter was taken up on the previous occasion, doubt arose whether evidence in chief was filed or not. So my instruction, it was filed on 21/10/2022. I have the office copy with me, and the order also reflects, Lordship, they did not face cross-examination. That is the reason, Lordship. Though the suit is of 2001, however, it was stayed for a considerable period, and after remand of the other case, Lordship, if I may refresh the memory, at page 28, annexure 2.
But then if the evidence is filed in 2022,
Lordship.
that means for 4 years, the PWs 1 and 2 did not come to.
Lordship, may peruse paragraph 10 of my petition once, which is at page 7. After reopening of the case as well, there was amendment of the plaint in 2019, and written statement, amended written statement was filed in 8/6/2022. Thereafter, issues were framed, and on 21/10/2022, the evidence in chief was filed, Your Lordship.
So that means 4 years, still it is 4 years.
4 years, Your Lordship. The plaintiff, the PW3 faced cross-examination.
And that, what is the relationship of the PW3?
PW3 is not related
with
to
the plaintiffs?
They are not related. Lordship, PW3 is an independent.
Not related. So order 18 rule 3A,
Lordship.
you have allowed somebody else to come as witness before you.
He is a person of the locality, Lordship.
But you know the consequences of order 18 rule 3.
Yes, Lordship.
But then how do you save this petition?
because of order 18 rule 3 only, the evidence of PW 1 and 2 will be required, Your Lordship. And the petition, Your Lordship, which was filed on that date, Your Lordship, when it was rejected, is at page 45. It was filed by the advocate stating that due to the illness of the advocate, he could not communicate with the witnesses and make them aware about the date. As such, they are not present, Your Lordship. At page 45, annexure 5. Your Lordship, so it is that the party should not suffer for the act of the advocate, Your Lordship. It is due to the ill health of the advocate. He could not communicate with the witnesses to be present. These two witnesses, Your Lordship, are crucial witnesses because Lordship has already observed order 18 rule 3. Because PW3 would have no evidentiary value in that sense, Your Lordship. Until and unless the plaintiffs come and step in and lead their own evidence.
No, you have to satisfy the test of 3 adjournments at under order 17 rule 1.
Lordship, another aspect of the matter, Lordship, but I have annexed at 4, page 42 onwards. The matter was also sent for ADR, Your Lordship, on a couple of occasions.
But your own showing at page 44
Yes, Your Lordship.
is that the case was fixed for cross-examination on 10/12.
10/12, Your Lordship.
So 10/12 goes, there is another date in between.
Yes, Your Lordship. And
No,
21/1,
10/12 is next day is 21/1.
21/1,
So even if the lawyer is ill,
Lordship,
the date of hearing was fixed
on 10/12.
10/12.
Lordship, if we assume that 10/12 was an adjournment, even if we assume that 10/12,
No, it's okay, but
Whether
you
it's
see the
done.
cross-examination is starting from 10/12,
Lordship,
even if you omit everything else.
Lordship. And 21/1 is the petition, Your Lordship, which is filed by the advocate, stating he could not inform the witnesses to be present, Your Lordship, due to his ill health, owing to his ill health.
No, you see, it doesn't help you.
Lordship.
Page 44 says that both sides are represented through the land council. Seen the report sent by the mediation center.
Lordship.
In mediation center, both sides would be personally present,
Lordship.
and therefore they know that that it has failed. And the mediator will normally tell you that please go to the court. But it is pending since 2022. We can't help it.
Lordship, the next date to my instruction is fixed on 17/6, Your Lordship, because these are crucial witnesses, Your Lordship, and in view of order 18 as well, Your Lordship. So if I may be given a permission, if I may be given a chance to produce my witnesses on 17/6, which is fixed for necessary
No, that
matters.
order we can't pass ex parte.
Lordship.
But you have to show us why should we interfere? This is evidence filed in 2022.
Order is not annexed here, Your Lordship. But
That's okay,
immediately,
whatever is there, if your evidence is filed on 21/10/2022,
yes, Lordship.
then more than 3 adjournments have already been taken.
Lordship. 3 adjournments may have been taken, Your Lordship. I'm not arguing in that aspect, Your Lordship. But due to the rejection of this petition, Your Lordship, last learned court could have, because the ground shown in the adjournment petition, Your Lordship, was not due to the fault of the parties, Your Lordship. It was filed by the advocate.
No, you see, Mr. Kalita is sitting behind. The lawyer took an adjournment on his cause, and 2017 we have not granted. So every time we don't grant an adjournment, merely for an asking. Mr. Kalita's matter was Because of 17, I'm making him sit here.
But here, in this case, your lordship, I would submit the ground of adjournment, your lordship, would be considered, your lordship. Because it was said,
That is only one. No adjournment within three hearing or 3 days of hearing in the British Order 17. How do you overcome that? Take a break and come back. Mr. BJ Mukherjee, and counsel for the petitioner. Sealing the order dated 21/1/2026, passed by the General Civil Judge within bracket Senior Division, bracket Bongaigaon, in TS 20 of 2021. Present application has been filed under Article 226(7) of the Constitution of India. As by the said order, the cross-examination of PW 1 and 2 was closed. Next, by the learned counsel for the petitioner has submitted that, notwithstanding that earlier adjournments were availed for the purpose of cross-examination for the PW 1 and PW 2 to face cross-examination, but on 21/1/2026, the counsel for the petitioner had submitted a petition that due to his ill health, the plaintiff side could not be communicated in time for which no evidence could be adduced. So it is also projected that on 18/2/2026, an petition was filed to recall the said order, which was rejected. Order dated 18/2/2026. Next, issue notice, return of announcement. Petition shall take steps within 2 days for service of notice on the respondent by speed post with AD. Next, as an interim measure into the next return of date, the further proceedings of title suit number 20 of 2001. Pending before the Court of Learned Civil Judge within bracket Senior Division, bracket Bongaigaon, shall remain stayed. Next, the petitioner shall produce a certified copy of the order before the said learned court. Bring the order to the notice of the said learned court. List of instances.
Item 7,
May I please, Your Lordship?
Yes.
In this revision petition, we have challenged an order which is at annexure 12, page number 110, Lordship. And we have filed two applications, for one for seeking for leave to carry out the auction process of the assets of the respondent number 2 that we have taken over, and another application whereby we have paid for issuing a direction to the respondent number 2 to produce the original copy of the lease deed, which was part of the evidence that we have filed before the land court. Those two applications were rejected, Lordship. However, we are mostly agreed by the second application whereby the direction to issue the to produce the lease deed was rejected, Lordship.
This
Already
is an execution proceeding.
execution, we have came by filing an application under order 21 rule 99, Lordship, because the land which belongs to the petitioner here, Lordship, which was leased out to the respondent number 2, who has mortgaged the leasehold rights of that to another bank, and they have taken the loan, which they have defaulted, and that resulted in the arbitration proceeding. We are not party to that arbitration proceeding. We came to know only by the execution proceeding when it was the Nazi went to the property which is owned by the petitioner, Lordship.
You're annexing the document and say that you did the,
We have
to produce the original, why?
We do not have the original copy because by the at the time of lease agreement, the original is given to the Lordship, to the lessee, because they can put that for mortgage to any bank or any financial institution, because the purpose of giving the lease was to augment the industries, Lordship. So the person who we do not have the original copy of the lease deed with the power.
But tell us, why in the execution, why do you need that?
Lordship, because the ownership of the land, which is in the writ of attachment, or which has been named in the award, Lordship, which belongs to the AIDC, the petitioner, Lordship.
And you want the lease deed to prove that?
Lordship.
You want the lease deed to prove that?
We need to prove that we have given the lease and we have only allowed them to have the leasehold rights to be
If it is
mortgaged.
Exhibit 2,
Lordship.
that means they have exhibited that document.
Lordship, they have exhibited, but they do not have the copy, so they have to prove it by the secondary evidence, Lordship, if the original is not produced by with the direction by the respondent number 2, Lordship. The respondent number 2 owns and possesses that original
And
document.
you have to ask someone sitting here how to lead secondary evidence if you want to lead that.
Lordship, because-
Exhibited document, if you find difficulty in proving that,
Lordship, that is the reason they
we
have
are
filed
only surprised. We can express our surprise, nothing else.
they have filed the application subsequently, Lordship.
Whatever, but this application is misconceived. There are many stalwarts here who will advise you how to exhibit a document.
Which is that has been done, which is they have filed it prior to filing the application asking for the documents, Lordship.
Then you will lead secondary evidence. Exhibit, somebody cannot deny. Find it surprising.
It was filed before, so the evidence was filed and exhibited before.
Two things we are surprised. That the lease deed, you don't keep it. You give it to the person who is taken on lease.
Yes, Lordship,
That is most wonderful thing, what you call a landlord can do. To give the original to the tenant.
because that is done and the
No, that's okay. We are just expressing
the
our surprise. We are not commenting
Lordship, that is the
whether it is
instruction
right
that-
or wrong, but we just surprised. Sorry, this is misconceived.
The evidence has been filed prior to filing the application, Lordship. That is,
But this would be misconceived. You have not even shown the evidence, how the evidence was led. Was it a document which was proved in original, or it was the original exhibit which was proved? That also statement is not there.
Lordship, that is not.
Then If it's an original document, it will go to C1 file. If it's a proved in original, then there would be an order sheet that the document was proved in, not in original, but in the copy and taken away. The court will always, when returning an exhibit, will write in the order sheet that the exhibit has been returned. There's nothing on record to show that. I think it's a misconceived petition. And you think that the plaintiff who had exhibited exhibit 2 will come and deny exhibit 2
Lordship,
when you put them questions?
Lordship, it has been exhibited by the petitioner hearing as an applicant in this case where they have, evidence is not by the plaintiff, Lordship.
Not by the plaintiff.
Not by the plaintiff, by the petitioner hearing under the.
Where is the order allowing you to do that?
Lordship,
Where is the order allowing you to do that?
Lordship, the order was, I think, Lordship, that is not on the part of the record in this petition, Lordship, that allowing us to file the evidence, Lordship. But however, Lordship will kindly come to the last order, which is impugned. It records the dissatisfaction with the evidence, Lordship. The very last page 112, very last paragraph, Lordship. Lordship, what it appears.
Just a moment. Where is your application and where is your evidence?
Lordship, the application is at page 105, Annex 11.
And where is your evidence on affidavit?
We have filed on page 86, Lordship.
86.
86. Exhibits were not been part of the record. We have taken in that statement.
The agreement is at which page?
Lordship.
The agreement was at, okay, 22. But what is wrong in this order, according to you?
Lordship, the rejection of the petition was only, Lordship will come to page 112.
Yes, we have seen that. That's why we are asking you,
Lordship,
what is wrong in that?
they consider us to be third party when they have, the Honorable Court has allowed us to lead evidence, and we are only seeking a
So you
document.
are still a third party. In an execution, when you are objecting, you are still a third party.
Lordship, and
There is no decree against you. There is no award against you.
Lordship,
Then,
but the land belongs to the petitioner hearing, Lordship. And the second part is considering as a third party in the evidence that we laid in the petition, which is filed by the petitioner himself, Lordship. And also, if an application has to be rejected, the satisfaction or dissatisfaction of the court should be recorded as per the order, which is, or as per the rule which is given in the Lordship. You kindly refer to Order 11, Rule 12.
Order 11 to 12.
Lordship.
Discovery and inspection.
Lordship, we have paid under that provision for production of the document with the direction, Lordship.
What is misconceived? In an execution petition, you want to invoke Order 11. Under which provision of law it is permissible?
Lordship, we have, that application was filed in that.
We understand, but under which, you see, something must empower you to do it in an execution petition. You see, you put the cart before the horse first. What you do is you file your evidence.
That was, that.
On the day of evidence, you don't say that this is a copy and you need the original. After 10 days, you file an application that I want the original from original.
Lordship.
And the original is not be produced by the decree holder. It has to be produced by the defendant number 2.
Lordship, who is a judgment.
You did not take steps against defendant number 2 to call for the document.
Lordship, there is no order to issue notices to the judgment number 2. That
Will
we have
not be, it is your wisdom.
Lordship,
You will ask the decree holder to produce the copy of his agreement with defendant number 2.
Lordship, we have not asked the decree holder to produce. The prayer is only produced by the opposite party number 2, which is the judgment.
But the order says that you have not taken steps.
Lordship, there is no order by the honorable court to issue, take
Not
any
even
steps
that.
on the,
Not
they are
even
the
that.
party respondent in
You
the.
are a government company. Please request the government to make available to all government departments invitation letter, formal invitation letter, just like you use for inviting people in marriage. Big invitation cards. We invite you to give the documents. You need order for everything.
Lordship,
Will it be you to make a prayer to issue notice, or it will be the invitation card which you will send for giving copies?
The order raised on the day when we file is to, the counsel for the opposite party number 1 will file the objection. It is no record with regard to the judgment. If nothing has
Please
been
tell me, if you want to produce something to be produced before this court, what prayer will you make? You will say that please pass order and then only I'll take steps against defendant number 2. Or you will come forward and say that please issue notice on defendant number 2 to produce the document. What will be your conduct as a lawyer?
Lordship, we would be praying for notice.
Then you have not done so.
Lordship, that has not been done.
Then we don't entertain those applications in execution. You must know how to proceed when you are dealing with an execution case.
Lordship, however, an application under Order 21, Rule 99 has to be tried as a suit, which has been allowed by
As
the,
a suit,
which has been allowed by the honorable
but you have
court.
filed your evidence first.
Lordship, that of course.
Then
Lordship, but the document is in the power and possession of the opposite party number 2, Lordship.
you
So
will
only the
have to
document has,
first taken, you see,
we have
if it
not.
is- if it's so kind of you to tell us, remind us about the power of order 21 rule 99 and 101 to treat it as a suit. If it is a suit, then on a day when the issues are framed, within 15 days of the issues framed, you will have to take steps before plaintiff hearing. So therefore, evidence comes later.
Lordship, that part, evidence part, that is
Correct.
filed before, that
Yes.
has to be, we
So
have to
if
consider.
that is there, then tell us when did you take steps? You took steps after the evidence, filing of evidence. Is it in compliance of order 11? Order 11 will come after evidence or before evidence?
Before evidence.
Then
That is a mistake that we concede to, Lordship. However, we pray that only the document is power in possession of the opposite party number 2. And that will be very pertinent, that ought not to have been done, that was not exhibited before the filing of the application, Lordship.
you see now the trial court's order is, the executing court's order is there that you have never taken steps on respondent number 2.
But the trial.
You are SFC under 29, SFC also. AIDC is no longer a SFC,
SF.
State Financial Corporation. Is
That
it
is
there?
a company, right? It's a state
It's not
financial,
an SFC now,
no, so only they give a land, it's not a financial corporation.
no finance. Can't help you. And you have no document to show your ownership of the land.
No, so that's the government land, which was asked the AIDC to, that land, that.
You have no document to show that you are the land. Hold on.
I
Very
have
good.
the instructions that they don't have any other document.
Very good.
Also, the arbitration award which came to the execution, we have never been party, we are not, we need to prove the clauses of the lease deed also, because the clauses does not empower them to create a charge over the property without adhering to the clauses which we have marked as an exhibit also. Which they ought not to have done prior to filing the application also, that. But that is not proved in original as the order reflects also. I think what has been,
You show us one step taken which is correct. how could you have filed an evidence without first ascertaining the documents you have? And in the document, you see the travel gate indicate the court indicated you earlier also. It says that the evidence which is being filed is not in accordance with order 18. That clear warning is also there in the order. Where is that order? Somewhere the trial court has made a mention that the evidence filed is not in accordance with.
In the same order which
In the same order.
Yes, sir.
So. Now, please tell us this agreement on which you are relying.
Yes, Lord.
Why? What is there in this document at page 22 to show that it is an authentic document? You give a lease. With eyes open that a lease created for more than 11 months is required to be duly registered. So you don't do that. In the agreement, you say that the stamp and registration charges will be borne by the lessee. And then with eyes wide open, you omit to comply with this paragraph G at page 31. That's it. So what will you do with this agreement? Please tell me, can it be can it be under section 49, can it be led as evidence?
That aspect has to be, but that is done in 2006 also. Then what instruction we have got is that point of time.
You lose everywhere. That's why we told you to show us one thing which you have done correctly. In this case.
That is 2006 also, we have done it.
Whoever has done it.
However,
you have a very good instrument in hand, the lodging an FIR. Do it. Sorry, we can't enter in this evidence. We can't permit by order of this court to be led as evidence. Under 49, it is bad.
I should only allow us the original document.
But you should have taken steps earlier. If it is not even a evidence, how can we direct them somebody to produce by virtue of our orders?
Only the original document may not be registered also. That
can you lead evidence? Can you lead evidence? Will it be read in evidence?
That.
Please see section 49. If you don't have the book, we'll give it to you.
The registration.
We'll give it to you. Yes, give this. See, 49, I think C would be there.
We received the evidence.
Document required to be compulsory registered. If not registered, shall not be read in evidence. Okay. Please read that. I'll remember. I have read it after a long time.
49. Effect of non-registration of documents required to be registered. No document required by section 17 or by any provision of the Transfer of Property Act 1882 to be registered shall affect any immovable property comprised therein or confer any power to adopt or be received as evidence of any transaction affecting such property or by conferring such power unless it has been registered, provided that an unregistered document affecting immovable property and required by the Act or the Transfer of Property Act 1882 to be registered may be received as evidence of a contract in a suit for specific performance under Chapter 2 of the Specific Relief Act, or as evidence of any collateral transaction not required to be affected by the registered.
Both clauses are not present in your case.
That's it.
Both clauses are not present.
That's it. It is-
Savings clause are not present in your case. So everything goes. Heard Mr. D. Decker and counsel for the petitioner. Next para. Agreed by the order dated 17/3/2026, passed by the learned civil judge within bracket senior division, bracket closed. This is which place? Sivsagar.
Yes, Lordship, Sipsagar.
Civil judge in bracket senior division, bracket closed, Sivsagar. In BJ case number 56/2025, arising out of M full stop EX within bracket ARB, full stop bracket closed, number 21 of 2024, by which the learned executing court was not inclined to issue direction for producing an unregistered lease deed within bracket, comma, which is exhibited by the petitioner in the said case as Exhibit 2. And accordingly, petition number 57 of 2026 was rejected. First time I said agreed by, let's take it out, by order this, they start like that. So accordingly, comma, aggrieved by the order dated 17/3/2026. Referred above, comma, the present application has been filed on Article 227 of the Constitution of India. Next, the learned counsel for the petitioner has submitted that the petitioner corporation has been set up for the industrial development of the state, and accordingly, being the owner of the land at IID Center, comma, Demo, to the respondent number 2 for setting up of an industry by executing a lease deed dated, unregistered lease deed dated 6/3/2006. Full stop. It is submitted that the in execution of an arbitral award for which money execution within bracket arbitration ARB number 21 of 2024 was filed before the court of learned civil judge within bracket senior division bracket was Sivsagar, comma, there is every likelihood of the said leasehold land to be attached and auctioned for realization of the decretal award. Full stop. Next, accordingly, comma, the applicants, the petitioners were the only petitioner. The petitioner was the third party to the said execution proceedings, has filed an objection under order 21 rule 99 CPC, read with section 151 CPC for so that the arbitral award is not executable against the plot of land measuring 500 square meter and the plants and machineries which were taken over by the AIDC on 5/4/2023, which is not the property of the judgment debtor. Full stop. It is the said application which was registered as MIG case number 56 of 2025. Full stop. The petitioner submitted the decree holder, the respondent for one hearing had contested the said application, and the petitioner filed the evidence on affidavit which was sworn on 6/2/2026, where reference is made to 8 exhibited documents. Full stop. You have the date of filing of this application? No.
Which,
The evidence on affidavit?
is, it was filed on 6.
The date of swearing.
It was filed on 7th, also.
Hmm?
7/2/2000.
The learned counsel for the petitioner submitted that as per instructions received, they said the evidence on affidavit was filed on 7/3/2026.
7/2 February.
Next para, on 25/2/2026, the petitioner had filed an application under section 151 CPC to go ahead with the planned auction of the properties taken over by the petitioner in terms of the lease deed dated 6/3/2026 and 24/11/2009. Now, where is this 24/11/2009?
Lordship, that is not part of the execution proceeding because there is another 2000 square meter which was allotted to them. However, that is not in dispute with regard to any arbitration proceeding.
It is submitted that the property involved in this application is not covered by the lease deed dated 24/11/2009. Full stop. On the same date, the petitioner had also filed a petition under order 11, rule 12, read with section 151 CPC, section 66 of the Evidence Act, for issuance of direction to the respondent Number two, to produce the original of exhibit two, which is the lease deed. Lease agreement dated 6/3/2006. And four more exhibited documents, being the authority letter dated 5/2/2026, no, only two. Full stop. The matter came before the learned executing court, and the said learned court by order dated 17/3/2026 rejected the said application by assigning reasons to the effect that the execution petition was by the respondent number one, and the applicant had filed, and the petitioner had filed the said petition for production of lease deed by respondent number two. And therefore, as a third party, the learned executing court was not inclined to issue direction. Moreover, the said learned court has recorded that the evidence on affidavit was sworn before the notary public, Kamru Metro, but the exhibited documents were not marked before any authority. And accordingly, it was observed that the evidence on affidavit was not as per the civil code rules and orders of the Gauhati High Court. Moreover, the said learned court had recorded that the said learned court had that the petition filed by the petitioner does not indicate that the said learned court had made attachment of any property of respondent number two, nor it is stated in the petition that any decree passed by any court has been transferred for execution within the jurisdiction of this court, of the said learned court. And that the petitioner had not taken any steps for issuance of notice on respondent number two in connection with VJ case number 56 of 2025. So accordingly, the petition was rejected. Next paragraph. The learned counsel for the petitioner submitted that as the objection to execution is required to be tried as suit, the application was filed under Order 11, Rule 12, to call for the original of the said exhibit 2. Next paragraph. In this regard, the court on perusal of annexure 1 to the writ petition, which is 2 to the writ petition, which is a photocopy of the lease agreement dated 6/3/2006. It is seen that the said lease agreement was handed over was for handing over the property mentioned therein for a lease for a term of 60 years from 5/9/2005. First of this, it does not appear from the said document that the lease agreement was a registered agreement. First of therefore, comma, there appears to be a bar under section 47 clause C of the Registration Act for reading the unregistered lease deed. Is required to be compulsorily registered under section 17 of the Registration Act to be read in evidence. Full stop. Moreover, comma, it is at the time of filing of the evidence or before it, comma, the petitioner should have taken the leave of the learned court for taking steps for production of the original exhibit. And in this case, the evidence was filed first and the application for calling for the records followed the filing of evidence. Full stop. In the evidence on affidavit, comma, it is not reflected that what was filed as exhibit 2 was not the original. Full stop. It is also noted that there is nothing contained in the evidence on affidavit to show that the original of exhibit 2 was not in the custody of the petitioner. We asked you a question, you said in the negative. You, in your petition, one of your petitions, you say that you want to go ahead with the auction. How will you go for an auction if you are not you are not an SFC and you have not taken over the property?
We have taken over the property, that is any loss when we have taken 5/4/2023, we have taken over the property loss.
How could you do it if you are not an SFC? You don't have a power to take over the property.
That's the lease deed permits them to, because of the pending dues, Lordship.
You have entered into the land
Lordship, we have entered.
without authority of law.
Lordship, we have, because
I understand.
the-
If I am your landlord, you don't pay me rent, in terms of the agreement, I just go inside and throw you out.
Lordship, because we have issued the so-cause and they have.
I understand. That is,
And they were part of the,
I understand. You approve of this. If I am the landlord and you are the tenant, you approve that under the laws of the state of Assam, I can just walk into your house, throw you out, take over possession of the suit premises.
Lordship, it was not thrown out, he has given a notice, he himself, he
understand.
agreed to that part.
You
And he have-
understand?
He have left the property and he has,
I'm asking under the laws of the
no,
state of
it
Assam.
has to be due process of law as in filing an application. But in this case, Lordship, the
If consent does not, what you call, vitiate the action taken if it is contrary to law.
but the tenant.
If I tell you that, okay, I can't give you money, you go and murder 10 members of my family.
In this case,
Let me suffer because I did not pay, I cannot pay you loan.
Lordship, the tenant, that lessee.
Don't, no point arguing on that.
Because so-causes were issued, he responded and he left the property.
That's good, whatever you have done, you could do and do it. That's not the subject matter for us. We just ask you a question because you say you are not an SFC. Full stop. Even in the It is only in the application filed under order 11 rule 12 CPC, which is petition number 57 of 2026 dated 25 to 2026. It has been mentioned that the origin of exhibit 2 was under the power and position of respondent number 2. Next, therefore, comma is there as it may. As the lease agreement dated 6/3/2006 creates a tenancy, a lease, which is more than, what is that registration act?
I'll just hand it over to you.
Registration act. Creates a lease of immovable property for term exceeding 1 year. The same is compulsory registrable under section 17 within bracket 1 within bracket small d of the Registration Act. Therefore, there is a statutory bar under clause C of section 49 of the Registration Act for receiving non-registered lease deed creating tenancy for 60 years as evidence in transaction affecting such property or conferring such power. Next, therefore, for reasons which are different from the one arrived at by the learned trial court, the court is of the opinion that once a discretion by the executive court has been exercised in refusing to call for the exhibited document, and when this court finds that the said document, even if called for, cannot be read in evidence, the court finds no reason to interfere with the order dated 17/3/2026. Passed by so and so and so and so. They accordingly, application is dismissed. Next, the registry shall transmit a copy of the order to the learned civil judge within bracket senior division bracket close Sibsagar to make it a part of record.
Obliged, Lord.
Yes, item 8.
Lordship, Media Council as both of will appear in this case is on the legs in some other board. If possible, maybe taken up at 2. Item 8.
Okay, you come in second call. Mr. Kalita, which was your matter? 2017 matter was yours. We refused adjournment.
Number 10, my lord.
Item 10. Just give me that file.
My lord, it may be
In this case, you prefer an adjournment.
Yes, Lordship.
Actually, DRT matter, my lord. You see, this application is of 2017. Why am I praying for an adjournment?
The senior counsel is out of station. K. Bhattacharya.
Pending for my lord. And the debt recovery tribunal is still pending. State. Yes. Can't be permitted. You want a document to be sent for forensic examination. Every order passed by the tribunal is appealable. Yes, yes. In my opinion, I have completely fitted section. And we have this a big bunch of record with nothing in it.
Your Lordship, I have no idea. We went
Section
to
20, my lord.
another city for,
You see, today is the day, Monday and today is Friday. We permit through video conferencing.
No, Lordship, you have to have the, going to the Baksha court, Musalpur.
Musalpur Court, Your Lordship.
No, wherever he goes, but he can always be available through our online system. We can have video conferencing.
Give us for that, Lordship.
Hmm?
Give us for that, Lordship. Next week, Lordship, date.
My lord, before lordship, my lord, it may be fixed on 3rd of June, my lord. Because thereafter I will go outside, my lord, but that is the problem. On the petition, actually, itself is not maintainable. But why it is pending for so many years? On behalf of Mr. K. Bhattacharya and counsel for the petitioner, from prayer for adjournment is made as he is out of station. Mr. P. K. Kalital and its senior counsel, assisted by Mr. G. J. Saikia, Learned counsel is present. The counsel for the respondent is present. Next para. It is noticed that in the process of challenging the order dated 19/9/2017 passed by the Debt Recovery Tribunal, Gauhati in OA 56 of 2012, the proceedings before the said learned tribunal has been stayed. Accordingly, it is made clear that on the next date of listing, in view of the fact that all orders passed by the Debt Recovery Tribunal are subject to can be subjected to appeal, let the matter be listed on 3/6/2026. The matter would not be adjourned on the next date of listing. You can say list on 3/6/2026. So there's as first item, whether it will be disposed of. No first item. We have more matters more than this, more older than this pending. Whatever. We have also called for the records. Record actually. It's not required. Why we call for the record is there, my lord. It's absolutely unwarranted. But why nobody pointed out all these things for so long? It is because of this bundle I had to open it up and see. Actually, my lord, actual case was delayed, my lord. In the meantime, several respondents died, my lord. Mr. Chaudhary, I would like to address you. That series of matter, first for me to examine, we don't need a hearing, my lord. There's no further hearing that is required. If you want to supplement something, it's another thing, but so far as the court is concerned, we don't need a.
Only one sentence I'd like to submit, my lord. In my submission, I did not say anything about the power of attorney because upon his date, that power of attorney has also lost its force. That is the only submission I missed the other day.
Just a moment. Just a moment. It will- Power attorney has lost its force.
My lord, the performance guide,
Oh, acha.
that I might have failed to point out before. That's all, my lord.
Mr. Ali? So far as the court is concerned, we don't need any further hearing. Lordship. So far as the court is concerned, we don't need a further hearing, subject to if you want to add something, that's all. So we close the matter. Heard Mr. M.K. Chaudhary, Learned Senior Counsel, assisted by Mr. R. Gauhati, Learned Counsel for the petitioner, as well as Mr. S. Ali, Learned Counsel for the respondents. Mr. Terrifically, hearing is concluded, judgment is on. Take it over. Yes, item 4. Yes, yes, please.
It appears it is not maintainable. I have seen also, my lord, judgments and provisions, my lord. It appears that it missed our point. We missed this point, my lord. Mr. Gupta was supposed to appear. He's left for some medical emergencies. I am there, my lord. Mr. Gupta has some medical emergency left. So I am there, my lord. We have seen, my lord. It is difficult to overcome this maintainability issue, my lord.
Okay, Mr. Datta, if it is medical emergency, we'll take it up on Monday then.
Okay, can it be on Tuesday, your lordship? Or Wednesday, or any date other than Monday?
Till Wednesday.
Wednesday.
Okay.
Item 4.
Both sides are represented. Submitted that. Sorry, A.K. Gupta. The counsel holding a brief has to leave for some medical reasons. Mr. Anand Datta and counsel for the respondent caveator is present. So, however, he raises a preliminary objection as to maintainability of this revision on the ground that both under section 8 of the Commercial Courts Act as well as under the proviso to section 115 of the CPC, this revision would not be maintainable against the interlocutory order. And in this regard, he has cited the two following cases, 1 and 2. Next one, be that as it may, as you have the reasons event, the matter stands adjourned today. We'll meet to my website, list on 3/6/2026.
Deeply obliged.
Time being item 8.
May I please, your lordship?
We have come against an order, Your Lordship, whereby our application under section 75, Your Lordship, with order 26 June 9, PPC has been rejected, Your Lordship.
Which page is the order?
Page 107, Your Lordship. It's a proceeding under Land Grabbing Act, Your Lordship. We have filed this application. May I read, Your Lordship? 107.
Once you saw only an opportunity was granted to cross-examination.
Lordship,
The opportunity was granted for cross-examination.
Lordship,
How do you agree by that?
that, Your Lordship, we have not, Your Lordship. That order is also there. We have annexed, Your Lordship.
So how you agree by this order?
Lordship, Your Lordship will kindly see. So today the matter is fixed for report of learned approach commission with respect to cross-examination of PWs. No report is yet received. Learned counsel for respondent submits that till date he has not presented witnesses as he was to file the aforesaid two applications today. Order dated 8/8/2024 reveals the report of the circle officer was duly received by this court and thereafter cognizance was taken and notices were issued to the respondents. Calling a press report of circle officer Lot Mondal would not serve any purpose and will waste valuable time of the court as well as officials of the circle officer. So now on that ground it was rejected. Now Your Lordship will kindly come to the circle officer's report at the before cognizance is taken, Your Lordship. This report was submitted. So that is at page 110. Now the land, Your Lordship, which they are claiming, Your Lordship, are different patta and dag, and my land also different dag and patta, Your Lordship. My case is that I have not occupied their land. This land, scheduled land, which they have been claiming to be under land grabbing, Your Lordship, that we have not occupied that, Your Lordship. That's our specific stand in the WS also. That is why we have applied for, Your Lordship, filed a petition seeking Your Lordship, a commission, Your Lordship. Your Lordship will kindly see how this report has been prepared by the circle officer, Your Lordship. Page 110. A proceeding has been gone on the basis of this, Your Lordship. With reference to the subject cited above.
Just a moment.
Lord.
This page 20 and 23 document is whose document?
Lordship. 23, your lordship, this is the Jamabandi, your lordship.
This is whose document, your or the
That is her,
complainant?
your lordship.
Complainant.
She has annexed along with her petition, your lordship. Now, your lordship will kindly see page 110 for a moment, your lordship. Last line of this, your lordship. The report of the circle officer.
Yes.
That as per alerts, the field verification and inquiry of the local people of the localities found that informant had taken possession of her land after the purchasing of erecting border wall over the land, but prior to 4 or 5 years ago, the opposite party has taken the informant's land in their possession by erecting the brick boundary wall over the said land, but during the inquiry, opposite parties are not found over the land. We are not even there, your lordship. That's why we have called for this, your lordship. We don't come within the purview of land grabber, your lordship. And the judicial time which learned trial court want to save, it will be saved if this inquiry is conducted, your lordship. And if it is found that we are not in possession of that land, she can always take over, and your lordship will kindly see her petition, your lordship. Here, your lordship, the report of the circle officer says 3 or 4 years back. And her petition says, your lordship, your lordship will kindly come to page 17, her specific statement in the petition, that the applicant's husband is working in ONGC at Sibsagar, so she is also staying with her husband and their children are working in different places outside Gauhati by taking this opportunity on 31/2024, your lordship. That is thus 2 days before filing of the petition, your lordship. Under Land Grabbing Act, your lordship, this, according to them, your lordship, this encroachment has taken place, grabbing has taken place. This,
You are reading which page?
Page 17, your lordship. Even if today she goes there and she can take over that land, your lordship. I am not in there, your lordship. I am not even in her vicinity, your lordship, not in the neighborhood. Trace map will reveal, your lordship. She has an ex, your lordship.
Where is that?
That's your lordship will find. Your lordship, it is there. Your lordship, case 1112, your lordship. My that number to come and 4 to 5. 112, your lordship will find 2011 is their land, your lordship. And our land is 4254.
Page number?
Page 112, your lordship. This is the original, your lordship, vernacular.
112.
112.
112 is a copy of Jamabandi.
No, your lordship. Just before that, your lordship.
Acha, 112A.
Lordship.
Okay.
Two 2011 is their land, your lordship. And our land is not in the vicinity. This is our land, is your lordship, patta number is 4254. Dark number 2365.
But then why you need a second report of the
Commissioner,
Because your lordship, once that report comes, your lordship, everything will be, this trial is not required to be proceeded. Your
no,
lordship.
but you see, whatever document the court has, you have to proceed with the trial on that basis. What is the difficulty in proceeding with the trial on the basis of that report at page 110?
Lordship.
What is your difficulty?
This is, your lordship will kindly see that this whole proceeding that has been going against me, your lordship, where I have neither occupied their land nor attempted, your
Not
lordship.
of that, whether you have done it or not, that's not the query right now.
Lordship.
The query is regarding the report. Once there is a report, why you need a second report?
This is because your lordship will kindly see how this report has been prepared, your lordship. Your lordship will kindly see. It says that but prior to 4 and 5 years ago, the opposite party had taken the informants and in their possession by erecting the brick boundary wall over the said, but during the inquiry, the opposite parties are not found over the land. Number one. Number two, I have not even been, your lordship, informed about this report.
That's a question of evidence. That's a question of evidence.
No, your lordship, this, your lordship, this.
No.
This report.
If we do that, the reason is very simple. You have the CPC with you.
Lordship.
You find out. Open order 26.
Lordship.
Rule 10(2).
Order 26, please. Rule 10. Lordship, report and depositions to be evidence in suit.
Yes. Now, once a report comes, whoever gives that report will be before the civil court. It will always be an evidence before the court.
Lordship.
Now, you see, when you give in a suit, what happens? Your friend is the plaintiff, you are the defendant. He gives an evidence. To counter that, you give your own evidence. Correct?
Lordship.
Therefore, at your instance, that report can always be called for.
Lordship.
When your turn for the evidence comes. But once there is an evidence, you then what is being done in the civil court is that the person who has done the commission, he is questioned. Now, if it will be the witness who will say how he gave it a finding, how he arrived at a finding that 4 years back you constructed.
Now, your lordship will kindly see that why this report is, your lordship, pre-cognizance report statutorily required to be submitted by the
They have done something.
And the
No, you did your own evidence.
no, I will, your lordship. But my case is this, your lordship, when I have not occupied your land, I have not
There
tried
cannot be an
to.
evidence before your stage. That's what we are trying to show it to you.
Lordship, that I
Order
have seen,
26
your
to
lordship.
10
What
to
has
become
fallen
an
from the
evidence.
Lordship mount, your
Before you come to the witness box,
Lord.
can you bring evidence on record? You don't know that.
No, that, your lordship, we cannot, your lordship, before.
And at your stage, you can always call the officer and then have him examined. Because what he says is on the basis of some record.
Lordship.
He will bring that record and show it to the court.
Lordship.
That how he arrived at the finding. That 2 years back he did something, 3 years back he did something.
Lordship. Now, your lordship, this says, your lordship, 9 says, your lordship, that order 9 says, if in any suit in which the court deems a local investigations to be requisite for proper for the purpose of elucidating any matter in dispute, your lordship.
That's
That is
right.
the point, your lordship, why
No.
we have been,
You see, that is the power of the court.
lordship,
And that is saved under section 165 of the Evidence Act
lordship,
or 169 in the new code.
lordship.
167 is the new code. This happens because the court always has a power, inherent power to ask some report to be called
Lordship,
for.
lordship.
Your case is not that. Because you cannot compel the court to do something as per your liking. That's number one.
No,
Second,
certainly, your
no, I'm just, that's not the end. I'm trying to explain something to you,
lordship.
not countering you. Second is that when you lead evidence, before that, this under the Land Grabbing Act for the civil consequences, it will proceed like a civil court.
Lordship.
At that stage, nothing prevents you from giving a list of witness, making that what you call the Latmandal or the circle officer a witness to call along with the record.
Lordship.
You can also take steps to call for the record.
Lordship.
So therefore, what I'm trying to ask you is, before the same thing which I asked earlier,
same thing in a different way. Now, at the stage of who will be the witness? The plaintiff?
Lordship,
Plaintiff's witness doesn't appear to be given and cross-examined.
Lordship. They have not come, that's why I'm like.
Whatever be, but his evidence on affidavit and the cross-examination is not there. So before exhausting the PWs, can we envisage something by which the court in 227 says that, defendant will lead the evidence? There's only one case I know of. I'll tell you. No, it's not reported. I think it's reported in GLR.
Lordship.
In that case, the defendant comes and tells the court that I may die very soon. And therefore, before the completion of evidence of the plaintiff side, please take my evidence. So that led to the trial court order, and then it came to the High Court. That is only one case where a person can move the court for an out-of-turn evidence. That is only permissible. So this is also not your case.
No, that is certainly not my case, Your Lordship. I am not seeking that. But Your Lordship, so far as that commission is concerned, Your Lordship, I just want to rely on one or two judgments, Your Lordship. I will place and Your Lordship will.
Yes.
The point is ultimately, Your Lordship, the ground on which. This is from Orissa, Your Lordship. Your Lordship, before that, Your Lordship may kindly take up the land grabbing act, Your Lordship. Your Lordship may kindly take up the.
Just a moment.
Lords. Put closer to smoking after her
Yes. Is which paragraph?
Lordship, Your Lordship is land grabbing rules, Your Lordship, 2013. It is part. No, Lordship, that's para 5, Your Lordship. When the controversy is as to identification, location, or measurement of the land or premise or object, local investigation should be done at an early stage so that the parties are aware of the report of the commissioner and go to the trial prepared. The party against whom the report may have gone may choose to adduce evidence in rebuttal. Hence, ordinarily, in such type of cases, local investigation should not be deferred to a stage after the closure of evidence. I do not mean thereby that in no circumstances can local evidence investigation be sought after the evidence is closed, but ordinarily it should be done before the parties adduce evidence. Hence, I do not accept the contention of so and so that in much as party has a right to and can adduce evidence of a survey knowing persons engaged by him privately with reference to the identification location, it is open to the court to decline to appoint a commissioner of local investigation under Order 26 Rule 9. In this case, the controversy can be resolved by locating the wall upon the measurement, that is to say whether it stood on plot number 306 or plot number 307, so the local investigation is essential. Now the earlier report, Your Lordship, it is under Your Lordship Land Grabbing Act, Your Lordship. Now, Your Lordship, after cognizance being taken, Your Lordship, we have come denying that we are not in possession of the land, scheduled land, Your Lordship. Therefore, a local investigation is necessary, Your Lordship. This is from Karnataka, Your Lordship, Para 7, Your Lordship. The only ground on which the application was dismissed by the court below that the plaintiff cannot appoint the commissioner before adducing evidence on his side, and the report of the commissioner is only to appreciate the evidence on record and not to collect the evidence on his behalf. This view of the court below is wrong. The purpose of the commissioner is to find out the actual position of the property which is in dispute, and not only after commissioner's report filed, the parties will be able to explain away any particulars in the commissioner's report. And even if there is any doubt in possession of the property, such doubt can be repelled by proper evidence which has to be reduced by the parties. Now, Your Lordship, ultimately, Your Lordship, this proceeding has been going on the assumption that I have tried to, and I have encroached upon their land on a certain date, Your Lordship, which has not been supported by, Your Lordship, corroborated by the report of the circle officer, Your Lordship, pre-cognizance report of the circle officer, Your Lordship. Therefore, Your Lordship, we have prayed for this, Your Lordship. This report itself is a vague, Your Lordship, in nature, prepared without hearing us, Your Lordship. This, Your Lordship will kindly see, the legislature would not have liked to put this, the provision for sending a report by the circle officer in the act itself. It has been put. Why it has been put, Your Lordship? So that some vexatious claims cannot become against some other persons, Your Lordship. To protect that, this report is required, Your Lordship. Now, if report, Your Lordship, when prepared, it should be in a manner which justified the finding of the report, Your Lordship. That has not been done here, Your Lordship. Vaguely, he is saying that 2-3 years back, we have occupied their land, grabbed their land, Your Lordship. That too by persons whose name has not been mentioned. And in fact, Your Lordship, Section 8(4) of the Land Grabbing Act says, Your Lordship, notwithstanding anything contained in the Code of Civil Procedure 1908 and the Code of Criminal Procedure 973, any case in respect of an alleged act of land grabbing or the determination of questions of title and ownership or to lawful possession of any land grabbed under this act shall, subject to the provision of this act, be triable in special tribunal. Then provided that if in the opinion of the special tribunal, any application filed before it is prima facie frivolous and vexatious, it shall reject such application without any further inquiry. That provision is also there, Your Lordship. Now it's to see, Your Lordship, whether that report will reveal everything, Your Lordship.
Where do you read that provision of the report for taking cognizance?
Lordship, that is rule, Your Lordship, 6, Your Lordship.
Rule 6.
Rule 6. Verification of application. Now, sub-rule 2, your lordship will kindly see in the report what is to be there, your lordship. The correctness of the statements made in the application. Then, your lordship, the facts relating to ownership, actual possession and use of the land concerned. That is not their actual possession, your lordship. And then, your lordship, such other particulars may be useful for criminal to arrive at a correct decision on claims made in an application, your lordship. Our prayer is to your lordship to elucidate the enquiry, your lordship. In fact, your lordship, to be honest, your lordship, without any attempt to occupy their land, your lordship, their land still, their land is there, they can always occupy it, your lordship. On suspicion, they file this petition, and we are now going to the court on daily basis, your lordship. That has been happening, your lordship.
You understand?
And your lordship's judgment, your lordship, was part of that judgment, your lordship. There are 17 of that judgment, your lordship will kindly see, subject to correction, your lordship. That is 2017 5 GLT, your lordship.
Yes.
Lordship will kindly come to the para 17, your lordship.
17.
17. From the middle,
Yes.
lordship, from the middle part, your lordship. Does, as per the scheme of 2008, your lordship, got it, your lordship.
Yes, yes.
Lordship. Upon cognizance being taken of the criminal offence of land grabbing, the special tribunal would proceed with the prosecution of the land grabber not only for the purpose of punishing him, but also to recover the grabbed land from the land grabber for restoring possession of the grabbed land to the person from whom the land was grabbed. If in this proceeding, the alleged land grabber takes up the defense of ownership, possession, or better claim over the land in question, the special judge tribunal shall first determine that question and keep the criminal trial in abeyance till such determination. I have not taken up that plea, your lordship. I have said that I am not in your land. I have not put up any defense, your lordship, that I have a better claim over a plot of land, that I am in possession of that plot of land. Nothing is there, your lordship. Only then your lordship has said that the court will go into the further inquiry, your lordship. I have specific affirmance in this that I am not in possession of that particular plot of land. That is why it becomes important for us, your lordship, this inquiry, your lordship.
You see,
Lordship.
I'm just putting a hypothetical question.
Lordship.
You asked for a report, and now in the report it says that, well, I did not say about that. Now we find that Mr. Bhattakur is in possession. Just hypothetically. Then what happens?
Then your lordship, then finally your lordship, that's what the truth is, will be, your lordship. He can go.
It's just a report. That's why we say.
Lordship.
It has to be cross-examined and then
Lordship.
defended.
Lordship. Lordship. But it will ultimately help both, your lordship, both me and as well as the petitioner, your lordship, in that particular case, your lordship. We are only trying to help them, your lordship.
We'll record your statement, but
Lordship.
we are not approving of that.
Lordship.
Mr. S. Bhattakur and Senior Counsel assisted by Mr. R. Sinsworth and Head Counsel for the petitioner. Next paragraph. The respondent has file a proceeding before the special within bracket LG bracket close tribunal, which was registered not very
Land grabbing case number 30/.
no, not that. In this, the applicant is only one. Why you pleaded two people? Page 14A, the complainant is only one.
Lordship,
Why you made two
the
people here?
respondent are two, your lordship. I am respondent, your lordship.
Oh, acha, you are both the respondents. Okay.
Lord.
Okay. But a complaint against I think the respondent has filed a complaint against the petitioners before the special tribunal LG, which is registered as special tribunal within bracket LG bracket close case number 30 of 2024. So in the said complaint, the respondent has accused the petitioners of committing land grabbing in respect of land measuring 1 kata 5 lechas covered by the Act number 782 within bracket old oblique 2001 within bracket new of KP Pata number 118 within bracket old oblique 931 within bracket new of village Betkusi BETKUCHI Moza Beltola under the dispute revenue circle in the district of Kamrup Metro with definite boundaries which is described in Schedule A of the said complaint. So in the said complaint, the accusation is to the effect that on 30 January 2024, the petitioners had illegally occupied the said land and threatened the respondent with dire consequences. The said complaint is pursued through a constituted attorney to stop. The learned counsel for the senior counsel for the petitioners has submitted that as per the requirement of Rule 6 within bracket 2, it's 6 within bracket 1 of the Assam land grabbing within bracket prohibition bracket 2013, the circle officer by memo dated 7/8/2024 submitted a report it is submitted that as per the said report, the respondent, the name of the respondent is mutated in respect of the said 1 cut of 5 lakh land and that the present petitioners are not the recorded patadar of the above mentioned land. Full stop. It has been further stated that as per the land record staff field verification and inquiry with the local people, it was found that the respondent was in possession of a land after purchasing by erecting boulder wall, BOLDER, boulder wall over the land. But prior to 5 years ago, the petitioners had taken the land of the respondent in their possession by erecting big boundary wall over the said land. But during inquiry, the petitioners were not found over the land. Stop. It is submitted that the said land is still lying vacant, and the same was never in possession of the petitioners. And therefore, it is submitted that as per his instructions, the petitioner would not come in the way of the respondents taking over the possession of their land, if they are entitled to. Next para, it is submitted that petitioners are owners of a different plot of land, and by referring to the placement of the trace map of the disputed land, it is submitted that the petitioners are nowhere close to the land of the, nowhere close to or in boundary of the land of the respondent. Accordingly, it is submitted that the petitioners had moved an application under section 75, read with order 26, rule 9 of the CPC for appointment of a commissioner to inquire, investigate and to submit a report in respect of the said plot of land. However, the said petition number 632/26 dated 12/3/2026 was dismissed and the matter was fixed for cross-examination of the PWs. Next, accordingly, the petitioners were aggrieved by the said order dated 12/3/2026, passed in special land grabbing case number 30 of 2024, rejecting petition 632/26. The present application has been filed under Article 227 of the Constitution of India. Next, in support of his submissions that in order to enable the tribunal to ascertain the status of the disputed land, it is permissible for a commission report to be called for under order 26 rule 9, even before the stage of evidence. It is submitted that the purpose of appointing a commission is to find out actual position of the property which is in dispute And that ordinarily such a report is required to be called for, because on the basis of such report, the parties would be aware of the nature of evidence which is required to be accorded of the led. In support of his submissions, reliance is placed on following two cases. That is this 2000, number 1, and number 2 is Orissa. It is further submitted that in the present case in hand, the respondent has not even, the petitioners have not even taken a defense of having possession or better claim over the disputed land. And therefore, neither the petitioners are in possession of the land, nor they have committed the act of land grabbing. In this regard, reference is made to paragraph 70 of the case of XXX versus in the state of Assam, 2017 within bracket 5 bracket close GLT 854. Next one. The fact which are unique to this proceeding under the land grabbing, Assam land grabbing within bracket prohibition, bracket Act, 2010. It may be stated that the law envisages determination of civil liability first, and thereafter the criminal liability is required to be ascertained. Full stop. There's a requirement under Rule 6 within bracket 1 of the Assam land grabbing within bracket prohibition bracket rules from 2013 that the special tribunal may refer for local inspection or verification of both of the land in question to the revenue circle officer or any other officer of the government authorized by the special tribunal in this behalf. Therefore, there is already a report before the government special tribunal, which was submitted by the circle officer, Dispute Revenue Circle, by memo dated 7/8/2024. Full stop. In both the cases of R. Narasimhaya and Mahendranath Paridas, referred to by the Learned Senior Counsel for the petitioner, though the evidence had not commenced, the High Court of Karnataka as well as the High Court of Odisha have taken a view that even if no evidence is led by the parties, by applying order 20, the provision of order 26, within bracket, rule 10, a report can be called for by the trial court. And it is in that aspect that it was held in the case of R. Narasimhaya within bracket Supra that the purpose of commissioner is to find out the actual position of the property which is in dispute, and only after the commissioner's report is filed, the parties would be able to explain away any particulars in the commissioner's report. And even if there is any doubt in the position of the property, such doubt can be repelled by proper evidence which has to be adduced by the parties. In the case of Mahendranath Parida within bracket Supra, the Odisha High Court held that when the controversy is as to the identification, location or measurement of the land, or premises or object, local investigation should be done at an early stage so that the parties are aware of the report of the commissioner and go to the trial prepared. There is no quarrel with the said proposition of law. However, in the present case in hand, there is already on record a commissioner's report. Therefore, without any evidence being led, create another report to counter the report which is already in existence would be counterproductive. In the event there are conflicting reports by the same authority, there will be more confusion than clarity on the nature of evidence which is required to be led. On the other hand, if the second report tallies with the contents of the first report, then it would create further confirmation of the fact which is already recorded in the first commission report. It is in this context, in the said context, the court is of the view that as the provisions of order 26 rule 10 within bracket 2 mandates that the report and depositions of the commissioner is to be evidenced in the suit of the proceedings, this court in exercise of jurisdiction under Article 227 would refrain from passing any orders to substitute its view upon the view already taken by the learned trial court and to direct creation of an evidence. In the present case, the facts is different from the facts on which the cases of Mahendranath Parida and R. Narasimhaya and Mahendra Parida were decided. In this case, there is a commissioner's report, and whether the same would be acceptable as a good evidence is to be tested by the witness to be examined by both sides. This one. Next one. We it may be stated that the learned counsel for the petitioner, senior counsel for the petitioner, by referring to the central office's report, has stated that, has submitted that when the inspection was carried out, inspection of the inquiry was carried out, the petitioners were not found on the land. Mr. Is also laid stress on the point that in the complaint petition, there is a specific averment that the land grabbing had occurred on 30 January 2024, and therefore it was not the immediate case of the respondent that the petitioners had grabbed the land. Four to 5 years ago from the date of inspection, the date of inquiry. Mr. However, if issue as to whether the in light of already existing report of 7/8/2024, which is prior to taking cognizance of the offence, can it be held that the order dated 12/3/2026 passed by the learned special tribunal is illegal or perverse, warranting interference under jurisdiction to be exercised under Article 227 of the Constitution of India. Full stop. Next, in light of the discussions above, as it is within the since it is open to the petitioners to deal with the Circle Officer's report dated 7/8/2024 in a manner which is in a manner which is to which the petitioners are well advised. But as held unit before, the court cannot envisage a situation where to counter one commission report, another commission report be ordered when the parties are yet to meet evidence. Next paragraph. Be that as it may, the observations made in this order shall not prevent or preclude the petitioners to make an appropriate application before the learned special tribunal to have the inspection of the land carried out afresh. Because as per the provisions of the provision of section 11 of the Assam Land Carrying within bracket Prohibition, Act 2010, the burden of proof is on the land grabber to prove that land has not been grabbed by the land grabber. Full stop. Next, the set observations as made above from the court is not inclined to interfere with the impugn order dated 12/3/2026, page 107. Stop. Next paragraph. Nothing contained in this order shall prejudice any of the parties when the matter is heard on merit. Mr. Protocol,
Lordship.
we have given you liberty to move to
Lord.
court again when required at the time. This time we are not interfering.
Lordship.
And second is that you can also deal with this report as you be so advising.
Deeply of the report.
Your book.
Orders, item 21.
John Rowe. 25 John Rowe.
Lordship, there has been a recent development in this case, Lordship. On 8th May, we have received an instruction in WPC 4617 of 2029, which was filed by one Runuma Begum. Lordship, she has filed one IA 1183 of 2026. And Lordship, the Honorable Court on 29/4/2026 has made a direction that in the meantime, status quo with regard to the service of the petitioner as on date shall be maintained. So, Lordship, I produced an instruction on the earlier date, Lordship, that after this MCC, the Model Code of Conduct is over, we will appoint Ms. Hadaya Begum in the position of as Anganwadi helper. But now, Lordship, because of this status quo operating in the other writ petition, we are not in a position to appoint the petitioner.
Okay, we She's normally there. Ms. Nargis is normally there. Today she's not there. We'll record her
My lord,
presence.
I'm here, my lord, online.
Here. Okay.
Yes, my lord. My lord, this petition was dismissed by your lordship because the petitioner, counsel for the petitioner could not appear during call lordship 2-3 times. So, my lord, that is why that was dismissed. So, lordship, in this case, already lordship heard the matter and passed the order, lordship.
No,
In-
here this is the review petition by the state because of the directions contained to
Yes.
pass, to give you compensation
My lord.
or to appoint you. That's the
Yes,
direction.
yes, Lordship.
For that, they have filed a review petition. And
Yes.
since this bench had passed the order,
Yes,
it
my
is
lord.
tied up with this bench, whereas the other writ petition, which is WPC 4617, is separately proceeding.
My lord.
So what we are proposing is that
My lord.
we give a judicial direction that this matter would not be tied up with this bench and it will be listed on the same day when WPC 4617 of 2019 is heard.
Yes,
Because
Lordship.
otherwise, there will be multiplicity of the proceedings and then you are not getting the benefit which was intended by order dated 29/5/19.
My lord.
So this matter would not be treated as.
But my lord, review petition is pending. That is why this
No,
matter
we are
is
not.
listed before your
You see, that is because this is the bench which has passed the judgment in the earlier case.
lordship. Yes,
So under the rules, it will come to this bench only.
my
But
lord.
that doesn't help you. You are suffering because of that only. Let this matter be listed along with WPC 4617.
My
We will request the other bench to take up the matter. Because of the unique situation here, there are two writ petitions for the same post. And because if it is kept tied with this bench, you will suffer more.
My lord.
State government is not suffering because they have to pay salary to A or B. So they are not suffering. You will be the main sufferer.
My lord.
Okay. Ms. U. Sharma, then counsel for the government advocate for the review petitioner, as well as Ms. S. K. Nargis, learned counsel for the respondent number 1. Next paragraph. This review application is tied up with this bench as this bench had disposed of WPC 4828 of 2013 by an order dated 29/5/2019. Stop. Next paragraph. The respondent number 4 in this review petition had separately filed WPC 4617 of 2019, claiming engagement to the post of Anganwadi helper in the same center for which reliefs were granted to the respondent number 1. Full stop. The next paragraph. Therefore, the court is of the considered opinion that if the matter is kept tied up with this bench under the unique circumstances where WPC 4617 of 2019 is also proceeding parallelly, the respondent number 1 may suffer prejudice. Stop. Therefore, under the said unique situation which arises in this review petition, the court is of the considered view that the review petition can also be heard by the same bench, which would be taking up the hearing of WPC 4617 of 2019 so that the review petition as well as the said WBC 4617 of 2019 can be heard analogously to avoid conflict of decision in both the cases. Next one, accordingly, the registry shall list the matter what is the next date in WBC 4617? Any date is given? Will it be,
Lordship, that I'm not aware of, Lordship.
we'll list this matter along with WPC 4617 of 2019. And this matter will not be treated as tied up with this bench. Next, as both sides are represented. Let this matter be listed before the appropriate bench taking up WBC 4617 of 2019 on 8/6/2026. Just to enable the said learned bench to pass an appropriate order for analogously hearing both the matters together. Full stop. Mr. Nargis, we are fixing it on 8th of June. Both matters will come up together. It will not be treated as tied up with this bench.
My lord, they are taking the advantages of the writ petition
We are
47.
taking it together.
My
That
lord,
is why we are tagging it together.
my
What
lord,
can we do is
4617, my lord, the petitioner of 4617 is also not working, my lord. The post is vacant right now.
That is not the issue. What can I do? Can I counter the order of a
No, my lord, no, my
of
lord.
a what you call coordinate bench with the orders passed here? No.
My lord, my lord.
Therefore, I am saying that you will
But
be.
this matter is not listed till today to my information, my lord.
No,
So it is
that is for the registry to take care. We have given a direction to list it on 8th of June.
My lord. 8th of June.
8.
My lord. Oblige, my lord.
Okay. Oh, I have to write, there is a reference today.
My lord.
Other matters will be adjourned. There is a reference today, I have to be there.